So welcome everyone to this round table on the promise and possibilities of mandatory human rights due diligence for workers. As I said a little earlier, my name is Shelley Marshall and I'm chairing today's round table. As I speak to you from Wurundjeri country in the Eastern Kulin Nation, I'd like to acknowledge that I'm on ceded land, which is international law's way of saying stolen. And although it's not our topic tonight, we should all meet again for a whole additional roundtable on whether mandatory human rights due diligence laws are currently or can empower Indigenous peoples in their struggles against corporations that are occurring around the world. So the impetus for this event was to launch the report that myself, Ingrid Landau, who's speaking later, Hila Shamir, who you've all met, Judy Fudge, who I think is online, Orette Van Heerden, who I've seen online, you can come on and wave, and Tamar Bake wrote. Now, we're all from different parts of the world and many different institutions, but we're all labour law scholars, labour sociologists, and labour rights activists and practitioners. And what that means is we've spent our entire careers looking at institutions that are in a fundamental way aimed at addressing the inherent power imbalances between workers and capital. And all of us have come to examining modern slavery laws, corporate reporting laws, and now human rights due diligence laws. And that's laws that mandate that companies examine and address the risks that they're causing human rights harm in their operations and supply chains and are held responsible for those harms. We examine those from a labour regulation lens. And we noticed that lens, this rich expertise about how institutions can address that inherent power imbalance between workers and capital, is rarely being applied to this quickly proliferating area of law. So that was the initial impetus. And what we didn't know when we organised this event was that the vote in the European Parliament over the Corporate Sustainability Due Diligence Directive would take place 4 days beforehand. So now we have the opportunity to hear what happened. What compromises occurred? What was strengthened? How confident are those who share the same concerns about workers' rights as us that the EU Corporate Sustainability Due Diligence Directive can benefit workers in global supply chains, keeping in mind that the most vulnerable are in the economic south or have migrated from the economic south to the economic north. So without further ado, I'd like to introduce our speakers and the order of events. I'm going to introduce our first speakers and ask them to come online, and then I'll go on and introduce our next speakers. So our first speakers are Ruwan Subasinghe, who's the legal director of the International Transport Workers Federation, and Jeff Vogt, who is the Rule of Law Director for Solidarity Centre. And they're going to be doing some scene setting for us, just so that we can start with this struggle that workers have about claiming rights against transnational business before we go on to talk about the directive and to hear from the rest of our speakers. So over to you, Ruwan and Jeff.
Thank you, Shelley, very much for inviting us to this meeting. We're both calling in from the International Labour Conference here in Geneva. So my end of my comments will bring us back to that. I think this is a really important report, and I really want to first commend all the authors on it, because I think they made a very important contribution to the discussion on human rights due diligence. Over the last 10 years, HRDD has become really a conceptual juggernaut that has gone without much question about its fundamentals, I think, and without an adequate reflection about how specifically is this going to be useful for workers and trade unions, right, in global supply chains. And we've seen, as the report I think well lays out, that in many cases, but by no means all, the human rights due diligence plans we've seen companies adopt in the last 10 years really have been quite superficial, process oriented, and involve little to no real involvement with workers and trade unions. That's not to say in every case, but I think that is reflected in the quality and the scope of the due diligence plans that I've seen, even those that have come up under mandatory regimes. So I think while I think there is, as a report I think well reflects, the human rights due diligence does provide the important opportunities for dialogue and prevention up front, and I think Ruwan is going to get into much more of that in his presentation. As a means providing justice, I think it's more of a mixed picture, and in fact, I think, as the report also indicates, there haven't been successful transnational cases on labor rights that really have been fully brought through to a final judgment. And we've seen again with the French due diligence law, another case not on labor, but being defeated by the courts in France. So, with which I guess I'll transition briefly to the French law. I mean, the French law now is now past its fifth anniversary. And, again, even with this mandatory regime, we've seen that plans are still quite vague, don't really have much of an appreciation for the risks involved, don't really reflect or map clearly supply chains, and or provide really much detail on how they plan to prevent or mitigate risks, in particular to workers. And again, as I just mentioned, the French courts have been quite hostile to claims brought under the French due diligence law. There's one case concerning labor rights against Yves Rocher, dealing with a number of labor issues arising in Turkey, has not yet been decided. So I think that will be an interesting case to see how that is addressed under the law. Another quick point I would like to make, I think, is, if we take a look, at, how effective this paradigm has been, I think it's important to look at what has happened under COVID, which was, I think, a real stress test for this concept, right? And I think, it did not weather the pandemic very well. We take a look at the cancellation crisis when we had brands around the world, canceling and refusing to pay for orders that have been completed, where the labor has been done, or were well in the process, knowing full well what the cancellation of those contracts would have as far as the impact on workers, right, and on unions, and went ahead with it anyway, and had to, a global campaign of unions and NGOs force some companies to pay up, right? But it's clear that a human rights due diligence paradigm fully embodied in the practices of company would probably have led to a different outcome than the one we saw. And we also saw suppliers using the contraction in demand throughout the countries that are manufacturing to target unionized factories for closure, when they had groups, companies with kind of groups of factories, and you're seeing a reduction in demand, were in many cases targeting the unionized factories, and again, without much of a response from the industry. So I'll just quickly pivot, knowing that I don't have a lot of time, is concerns around access to justice. And I think the way that it hasn't been terribly framed well at this point, because I think, again, a lot of this was motivated by kind of the Rana Plaza disaster, and that is a case where you have death and injury, which fortunately can be quantifiable in kind of in a compensatory way. But when we think about union busting
I think we lost Jeff.
Well, if we lost Jeff, we lost Ruwan as well. And that just says something about the Wi-Fi. Oh, here they are again. Great. Welcome back. The last words we heard you say were union busting, Jeff. Oh, and you seem to be muted.
Done. So
All right.
yeah. So figuring out how to compensate for a victim of a building collapse is one thing. How you compensate workers for having their union busting is another. And if your remedy is compensatory damages, that doesn't really help you, right? So we need to be kind of more, have a broader set of remedies available to us and think differently about how we think about issues of remedy. Very briefly, because I know zero time, there's still questions about which companies are covered, burden of proof issues. And again, this could be very difficult if you have workers in Cambodia who are bringing a claim against Carrefour, who will assert a defense of having a plan. And I'm not picking on Carrefour for any particular reason. It's just a French company that came to mind. Without access to discovery and information, it's going to be very difficult to sustain some of these claims, right? The time and cost of litigation, again, the limitation to compensatory damages, and the difficulty in quantifying damages will be difficult. Unfortunately, I think the EU Commission's proposal, as Ruwan and I have written about, I think has a number of limitations. I think what came out of the European Parliament last week goes a good way in addressing some of those limitations. So we commend the European Parliament for having taken the initiative to try to improve on the Commission's proposal. And hopefully, as this moves forward in the trialogue, the improvements that the Parliament have put forward will stick. Last point I would say is just being here in the ILO at the International Labour Conference. I think it's just fundamental to emphasize, much of what we've had in terms of CSR with auditing and even with human rights due diligence are substitutes in many ways for freedom of association and collective bargaining, right? If we had made sure, like this organization had determined in 1919, right, that if we want social justice and peace, right, we need to promote the right of workers to have unions and bargain collectively. And trade union density in the private sector worldwide is quite low, right? And human rights due diligence has not altered that fact, right? So we really need to be thinking about how does this paradigm really lead to more unions, more collective bargaining across supply chains. And that fundamentally, in my opinion, and I think really needs to be what the outcome of human rights due diligence is if it's really going to be lasting and sustainable and effective, is this winds up in more unions with more agreements that are fundamentally able to determine the terms and conditions of the work, not only in the country in which they are, but as a matter of across supply chains. And I realize I've probably taken up too much time, so I'm going to pass it to my colleague Ruwan, who will take it from there.
Thank you, Jeff, and good morning, good day to everyone. So I also, first of all, wanted to thank and congratulate the authors for a fantastic report, which I must say will also be a very useful advocacy tool for us in the global trade union movement. So thank you for that. I think Jeff's already started a discussion on looking at HRDD legislation, or rather the concept and practice of HRDD from a process perspective versus an outcome perspective. Certainly for us as representatives of workers, we are concerned about process in terms of the ability of HRDD and HRDD laws to prevent harm, which of course is the best case scenario, but also given the current context, the access to remedy, which of course sits outside the HRDD framework, but it's absolutely linked, is critical for us from an outcome perspective. So just to give you an example, I represent seafarers and other transport workers in global supply chains. Now, in the example that Jeff gave on order cancellations and non-payment of wages in the garment industry, I think what a number of companies sadly forget is the workers who are involved in transporting goods from location A to B to C, from looking at the cotton that made that shirt, how that's transported to factories and ultimately to stores. Now, seafarers who make up about 1.8 seafarers in the world's merchant marine are effectively mobile migrant workers who are predominantly from the Philippines, India, Ukraine, and Russia and China, who sadly, go through, have terrible working conditions for the most part. And one significant area that they particularly suffer from is non-payment of wages, when ship owners have systems of double bookkeeping where they get underpaid effectively. And I've got to say that ITF inspectors, we regularly collect over $30 million in back pay that was otherwise owed to seafarers every year. So this is a significant problem in addition to other issues around seafarer abandonment, which can also give rise to situations of forced labor. Now, a lot of these issues are certainly not on the radar of most brands and multinationals. So when it comes to HRDD, from an ITF perspective, we saw this as a huge opportunity to make brands aware of their HRDD responsibilities when it came to maritime labor, because previously it was and it still is to this day a blind spot. So what would we say assist transport workers and seafarers from an HRDD perspective? Well, we accept that risk prioritization can take place based on severity of harm. So we think that'll be very useful for shipping to be recognized as an at-risk or high-risk sector. So if we look at the text that was adopted by the European Parliament on the CSDDD, we know that fisheries, for example, is recognized as a high-risk sector, but not shipping. So again, I think we need to reflect on which sectors are categorized as high risk and why that's done so, and that is not done in an arbitrary manner, so that we can also assist companies in the risk mapping exercise, but also to ensure that they conduct heightened due diligence for at-risk sectors. Now, we talked about wage theft, underpayment of wages, and this brings me to the point around the scope of rights covered under HRDD legislation. Now, broadly speaking, we say from a labor rights perspective, we're looking at the International Bill of Rights and the ILO's fundamental principles and rights at work, which of course together cover a bulk of labor rights. But if we are saying that issues around wage theft are prevalent, why not consider including ILO Convention 95, for example, as a source of rights on the protection of wages? Why not consider including the Maritime Labor Convention or ILO Convention 188 on work and fishing if we recognize these as at-risk sectors? So one good example of this, I think, is in the European Parliament text that was just adopted. Convention 189 on domestic workers is recognized. So if one particular category of vulnerable workers is recognized, I think that is going in the right direction in terms of identifying a source of rights that goes beyond fundamentals and the International Bill of Rights. I think it's also worth noting that the Norwegian law explicitly refers to a living wage, for example. So I think we need to move beyond the standard formulation in the UNGPs of just looking at the International Bill of Rights and fundamentals. Now, the next point really is a practical one, because as I said, proper risk mapping is absolutely key, and this cannot happen without meaningful stakeholder engagement with trade unions. And by trade unions, I mean trade unions at all levels, local, regional, and international. And this has to happen throughout the HRDD cycle. And one of the great things that came out of the report was the suggestion that these should be made enforceable obligations. And we absolutely agree. And we have to also welcome the latest EP draft, which recognizes the explicit role of trade unions as stakeholders, because we do think we are a very particular type of stakeholder and that needs to be specified. And similarly, in the German HRDD law, of course, works councils have been given a particular function in terms of the grievance mechanism and risk mapping. This is very good. Whereas the French law makes it optional on companies to consult stakeholders in their risk mapping exercise. So this is another key area, I think, that we should focus on. I think in the interest of time, the final thing I'd say is, again, touching on Jeff's points around the need for proper recourse to justice. So what we're seeing in the European Parliament adopted text in terms of civil liability and access to justice, with all of the things that Jeff mentioned around the reversal of the burden of proof, access to information, these are absolutely critical. And we think that this is really taking HRDD to the next level. And without a complementary civil liability regime, HRDD could, even mandated HRDD, could be meaningless. And this is very important also because Jeff highlighted the French devoir de vigilance law, and in fact, the ITF was the second labor organization to file an official notification letter under a company that's covered by the law. And of course, once we did do that, the company in question did amend their vigilance plan, made it look much better. But of course, the difficulty for us to bring a claim is to link that faulty plan with harm, which is the test under the law, which made it almost impossible for us to bring proceedings in France. Therefore, a proper civil liability regime that is separate from the obligation to conduct HRDD is going to be critical, and we think that is the way to move forward. I think I'll leave it at that for now. Thank you.
Thank you, Jeff and Ruwan. Wow, you are amazing timekeepers. That was really so on time and so succinct and to the point. Thank you so much. I thought it might be really useful for our audience if you wanted to put a link to your article in the chat so that people can read your fantastic blog. Thank you so much.